Doing a will is very important, as we've discussed on this platform before, and it's an issue that doesn't get tired. It remains ever relevant in people's lives. It's recently been discovered that the late great songstress Aretha Franklin actually did write up what she believed would be sufficient documents to be considered a will. It seems a few of these different documents were found in different places around her house, including among some sofa cushions. Initially, it was believed that she had not left a record of her wishes because she didn't leave any formal documentation with lawyers or a family member or anything like that. This story is an excellent tale in seeking to persuade people who may be tempted not to do a DIY will. To share her wisdom on this issue, I'm joined on the line by Hilary Dudley. She's Managing Director at Citadel Fiduciary. Hilary, thanks very much for coming on the show. Before we get into South African law and the nitty-gritties around doing a will in South African law, in the Aretha Franklin story, what's the latest in terms of whether the various documents she wrote have been authenticated and whether they're worth the paper that they're written on?
Nomfu, I was actually looking into that earlier today because the last I heard is that the family were due to approach the court on the 12th of June for some guidance as to whether any of the documents would be accepted as her last will and testament. And I haven't been able to come up with anything in the research that I did which indicates what developments have occurred. I will continue to look, and I wasn't looking at legal documentation,
yes,
but clearly at articles in the press.
Yes,
and it doesn't seem that anything's been reported as yet following that court hearing on the 12th of June.
Okay, so now let's come to the South African context. Well, in any context in the world, why is it important to write up a will?
Nampu, I think probably one of the key things or one of the key reasons to have a will in place is that you can record your wishes as to how your assets devolve after your death. So it's a key document to indicate what are your wishes when you're not around to speak for yourself anymore. And that's probably one of the most important reasons. There are in South Africa and in other jurisdictions certain fallback provisions where if you don't have a will, the laws in place that will determine how your estate will devolve in a fair way. And in South Africa it's called the Intestate Succession Act, and that dictates to whom your assets will devolve. So normally to family members, blood relatives, and to your husband or wife.
Yes. And
there are similar laws overseas as well. So that's one of the key reasons for having a will, is to retain control of the process. But there are other reasons as well. For example, if you have minor children, you'll want to appoint a guardian for them, because if a guardian's not appointed in terms of a will, then the family has to make application to court. So there are various other reasons other than your assets why you should have a will in place. So
yes,
often we find that people will say, oh, I'm not very wealthy, I don't have a lot of assets, I don't need a will. And we differ from that there are other reasons why you would need a valid will in place.
Yes, the little that you have, you want to ensure that it goes to whoever you want it to go to. So what?
Yes.
So what are the dangers of doing a DIY, do-it-yourself will, as the late Aretha Franklin did, especially when it comes to things around understanding issues on tax implications and so on?
Yes, I mean, that's a key issue, particularly if you have an estate of worth more than 3.5 million rand here in South Africa, you could be liable for estate duty. But other issues to consider, for example, in her situation, she has a special needs heir. Her eldest son apparently has special needs, and it seems he can't look after himself or manage money, from what I've read. And so no provision has been made for him legally, although in one of her handwritten wills she did leave instructions as to how her son should be looked after. There was nothing formally put in place to assist with that. And so there are those kind of nuances where someone might need advice other than for managing tax. For example, another issue, if you don't have a formal will appointing an executor, then your family members have to approach the Master of the High Court to nominate an executor. So it's better if you have a will where you nominate the person who'll be in charge of winding up your estates after your death. And that'll avoid a delay in that process. Another issue, for example, is if you have a valid will, it exempts your executor from putting up what we call a bond of security, which is similar to an insurance policy for the proper administration of your estate. And if your will doesn't exempt your executor from putting up security, or if you don't have a will, then the Master of the High Court will call for security, and that's an unnecessary expense in your estate. So money that could be going to heirs is spent in the administrative process.
Yes. Hilary, is it expensive to get a will done? I've heard that you can go to your bank and have it done for free.
Absolutely, Nampu. And my understanding is the banks will do a free will, but you just have to check with the bank whether they'll charge to store your will. So there are various ways that people do things. So, for example, an attorney might charge a fee to draft the will and then store it in safe custody for as long as you need without charging. Remember, you have to submit the original will to the Master of the High Court when someone dies, so the original has to be kept safe and prevented from being destroyed or being tampered with. So, as I mentioned, the attorneys will normally charge a fee but not charge for safe custody, whereas often the banks will not charge the upfront fee, but then you'll see a debit order going off your account annually as a safe custody fee.
Oh, right, okay.
So, and then I want to mention as well, there is an initiative by the Law Society of South Africa called National Wills Week, and that takes place annually, and this year I see it's on from the 16th to the 20th of September, and many law firms participate in National Wills Week and offer free wills to members of the public who need assistance. And I'm aware that other fiduciary service providers also participate and do wills for people.
That's very good. So between the 16th and 20th of September, South Africans can go and get a free will at a law firm, but they have to do the research as to who's offering that.
Yes. If you go to the Law Society website, I think they do have a register of which law firms are participating, broken down per province. So it's not necessarily every law firm that offers it, but you can go and check whether the website, I think they do have a register of which law firms are participating, broken down per province. So it's not necessarily every law firm that offers it, but you can go and check whether a firm is registered as a provider.
That was Hilary Dudley. She's the Managing Director at Citadel Fiduciary.